Good noontime, peoples. Thank you to the moderator in the chat. Listen to what she says, do what she say, do what she say. All right, so we're doing a reading for the Rule of Law seminar today from a book called Law and Judicial Duty by a man named Phillip Hamburger, like the sandwich. All right, and so we are now on page 44, which is the altered relation between different levels of law. So he begins. The recognition of authority and will as the basis for legal obligation relaxed the relationship between different layers of the law in the way that left men and all the more freedom in making their law. It was not simply that authority and will, whether popular or governmental, were increasingly understood as the measure of legal obligation. In addition, the shift to these sources of obligation loosened up the relationship among laws and thereby enlarged the space available for the exercise of human authority and will. So basically what he's saying is that the loosening up of laws in the relation to, say, a king saying, here's what you do or I'll cut your head off, versus America or a more common law situation, even Canada or whatever, right? Where you can do what you want within the confines of the law, right? Opens up the law to more people to be free and act as they would wish, right? All right. When law came to seem binding, because it was willed by a body with lawmaking authority, there was no longer any need to conclude that it participated in the eternal reason of any other higher law, and this left men free to make law as long as it did not contradict any law of greater authority and obligation. If law had to participate in eternal reason, each layer of law was but an aspect of the single larger order, and each part of it was obligatory because it shared in the reason and justice of the eternal law. If law, however, could stand only on the authority and will of its maker, without participation in any eternal law, then each law more clearly stood apart from any higher laws, and had merely negative relations to them. Thus, in the 16th and 17th centuries, the question of participation in the eternal order of the universe was largely displaced by a simpler question about avoiding contradiction. This was a subtle shift in emphasis, but by freeing each law from having to participate in a higher reason and justice, the new prominent role of will left each law less completely dependent on the laws that stood above it. The shrinking role of eternal law was evident, for example, among English Protestants. Calvin had so doubted the capacity of men to discern the eternal through reason or natural law that he urged men to attend to the moral law, the scriptural testimony of natural law to which God gave obligation through his eternal and unchangeable will. And many 16th and 17th century Englishmen eventually went further in this direction. Although some English Protestants, such as the Anglican apologist Richard Hooker, still accepted that eternal reason could be found in lesser forms of law, others, such as the Puritan moralist William Ames, collapsed the eternal law into natural law, thus, in effect, renunciating the top of the hierarchy. He suggested that the phrase eternal law was really just a name for an aspect of the natural law. Quote, the right natural or natural law is the same which usually is called the eternal law, but it is called eternal in relation to God, as it is from eternity in him, and it is called natural as it is engrafted and imprisoned or imprinted on the nature of man by the God of nature. Chief Justice Edward Coke similarly spoke of lex eterna, the moral law. Go away, caller. Lex eterna, the moral law, and called also the law of nature, and shortly afterward emphasized that, quote, this law of nature indeed is the eternal law of the Creator, end quote. These men could afford to reduce the eternal law to the enduring character of natural law, for they did not assume that human law had to participate in the eternal order to have obligation. A hint of how this development opened up space for human will can be observed in notions of adaphoria. Aquinas, talking about Thomas Aquinas here, right? Thomas Aquinas viewed all law as just, including and regarding adaphoria. As already seen in Calvin, however, many 16th and 17th century commentators increasingly took other views. Assuming that law was obligatory because it was willed rather than because it was shared in the rationality of a higher justice, they relied on the classical view of Ediphoria to defend human laws that were neither just nor unjust. On behalf of the English Church, for example, Thomas Starkey observed that there were things indifferent which were by God's word or scripture neither prohibited nor condemned, but left to the worldly policy whereof they take their full authority. More broadly, on behalf of the crown, Starkly noted that things could be indifferent not only within divine law, but also within natural law, and that the obligation to obey in these indifferent matters was a matter of human authority. Quote, to be obedient to the laws civil, so long as they be not contrary to the law of God of nature, it is every virtue and honesty. Yet to this law or that law, all men are not bounden, but only such as receive them as to be under the dominion of them which have authority in making thereof. Basically, like, you're only bound by laws that people who have the proper authority to make the laws make. Can't have randos out in the street making laws that actually bind people to behave a certain way. You have to have people who have the authority to make laws in order for people to be bound by them, right? All right. Thus, while some nations reputed it a certain virtue to abstain from eating flesh upon the Friday and to marry but one wife, other nations could follow different approaches. So candid a justification of arbitrary laws would once have seemed abhorrent. Now the Englishmen, however, place the obligation of their laws on the lawmaker's authority and will, they no longer expect their laws to participate in the eternal reason of the universe, and they therefore merely had to consider whether their laws kept within the bounds set by higher laws. The new relationship among laws, such as that a law had only to avoid contravening laws of greater obligation, had even more profound implications outside the realm of Ediphoria. The English tended to think in terms of Ediphoria when worrying about church government. Ediphoria being the matters in which government enjoyed the freedom of religious regulation within the substantive limitations set by divine and natural law. As to civil government, however, the English increasingly asked not so much about particular substantive moral limitations as about the general scope of the ruler's authority to impose his will, and whether the limitations on his authority were to be found in natural law, scriptural law, or human law. The laws delineating his authority were all the more clearly a measure of his freedom when it was recognized that he merely had to avoid contradicting them. So not asking whether or not a law is good or just, it's just, does this law you're making contradict any other law you already made? That's what he's saying. So instead of having to make a law that participated in the rationality of a higher law, a ruler now only had to avoid colliding with the legal boundaries of his authority, like I just said. The changing perception of human nature, or at least the perception of such a nature in a changed society, thus left Europeans with an altered vision of law, of freedom, and of government. In circumstances in which it was no longer plausible to expect men to participate in a higher law, men merely had to avoid violating the law, and this left them more free, at least within their authority under the law. Put another way, freedom shifted from a matter of justice to a matter of authority. For the people, their authority under natural law would come to be their liberty to make a constitution. For the ruler, his authority under the Constitution would come to be his constitutional power, including his freedom in devising laws. For individuals, their authority under the law of the land would come to be their civil liberties. Quote, a liberty to follow my own will in all things, where the rule prescribes not. End quote. This liberty to exercise will under law, however, arose from a diminished moral expectation about men and about their governments. Europeans had once been apt to recite how men, including rulers, could have the intellect and dispassion to exercise their will in a way that participated in the eternal verities of reason and justice. Now, Europeans pay greater attention to their fears about the corrupt character of men. Whether rulers or subjects, men seemed so limited that perhaps they could at best be bound by law, ideally by natural law, and no more certainly by human law. All right, now we're on to the section called intent. It has been seen that in the newer version of the hierarchy, authority gave obligation to the lawmaker's will, and this is as much as to say that the authority gave obligation to the lawmaker's intent. Today, intent seems little more than a judicially adopted interpretive method, a path not evident in the nature of the law, but apparently laid down by judges and thus perhaps within their discretion. Once, however, intent was understood differently. It was the will of the authoritative lawmaker, which seemed, amid the fractiousness of men, to have been established by God as the origin and measure of legal obligation. Put more sociologically, when men, in response to changes in their society, lost confidence in their capacity to agree upon what they found just, they found legal obligation in the will of the intent of the lawmaker. Not surprisingly, common lawyers rapidly assimilated the view that intent rather than eternal justice was a measure of legal obligation. But they did so with a distinctive common law variation. At common law, the formality required for lawmaking was that there be an act of a court of record. And when common lawyers became convinced that intent was the measure of obligation, they ended up focusing not merely on the intent of the lawmaker, but more specifically on the intent of legislative acts. It was not just any intent or command of a lawmaker that can make law, for rulers sometimes expressed their will irregularly, independently of the law rather than through it. This absolute power increasingly seemed to be of a very different character from the ordinary power to ordain law, and to understand the distinction, it is necessary to briefly step back to the Middle Ages. Already, within the old hierarchy of reason, in which intent was not the measure of obligation, intent was but a necessary element of human law, and men began to worry about intent ordinarily conveyed through human law might sometimes be pursued above it. If the highest of rulers occasionally exercised his will outside of the channel of his laws, then perhaps earthly rulers might also at times have to take extra legal measures. The possibility of miracles and of divine forgiveness could seem to suggest that God himself sometimes departed from his natural law. And far from being merely an academic question, this was like equity and pardons, a problem that potentially reached deep into the nature of the universe. It was only to be expected that human language could not adequately capture the complexity of the world, and that human rulers might therefore sometimes have to act in a manner that cannot be reduced to the regular generalizations of the law. But if God himself sometimes exercised his will absolutely beyond his law, and then perhaps the universe itself was not essentially regular or subject to the law. The disturbing implications for law, as for science, as for philosophy, as for literature, would take many centuries to unfold, and it was probably not a coincidence that in both physical and moral inquiries, such notions about the fundamentally fractured character of the universe only flourished with the disintegration of command relations in recent centuries. In the meantime, medieval kings did not have to resolve the profound questions about nature or even mere sociology to exercise a human version of divine power above the law. The learned advisors told them that a power above law was characteristic of sovereigns. Advisors told them that a power, characteristic of sovereigns, both divine and human, and the kings were human enough to be persuaded. Irregular will, however, was not law, and therefore, in a country such as England, in which legitimacy was so closely associated with rule through the law, the crown in the Middle Ages tended to avoid making open claims for the king's irregular or the king's absolute will. Although English monarchs asserted prerogatives above the law of the land, they remained cautious enough to avoid generalizing that this was what they were doing, it being safer to leave ambiguous whether such prerogatives were exercised through the law or through the law of the land or above and over it. In fact, the will that increasingly seemed to be binding in England, whether to make law or to make lesser sorts of legally binding orders, not only had to be regularly ordained, but also usually had to come through the formal act of a court. This sort of formality is all too often forgotten, but whereas learned continental theories of legal obligations require publication of a ruler's will, the English tended to accept the act as binding only if it was the act of a court. Basically, so in continental Europe, France, Italy, Germany, etc., that a king, a sovereign's, an emperor, whatever act would be legally binding if it was written down, right? English tend to say, according to this, that that's not enough. The king, you can't just have something in writing and make it a law. The court has to actually review it, and the court has to accept it, or the court has to say, okay, this is good to go. All right. The underlying assumption being that the court of a community was the place where the community itself could act. Such a court included a manor court, the corporation's court on a board, a colony's general court, all above above all the parliament. Summarizing this tradition, Koch observed that even when the king is merely commanding that a person be arrested, the king cannot do it by any commandment but by writ, or by order or rule of some of his courts of justice, where the cause dependeth according to the law. Indeed, there were some acts that the king could only make by act of record in a court of record. Quote, the king, being a body politic, cannot command but by manner of record. For rex principi, lex procipi, the king orders and the law orders are all one. For the king must command by manner of record and according to the law. The king made his lesser acts through various inferior courts of record, and he made his statutes in Parliament, which was the highest court of record. This enactment of English statutes as acts of record defined their obligation, for every record imports a truth in itself. And although one could challenge the operation of a record, one could never aver to the contrary of that record. The act of a court of record was thus the formality required if an enactment of legislative will was to have obligation of law. And already here it should be added that this formality, which seemed essential for the king in Parliament when making statutes, would one day also seem necessary for the people when they enacted expressed constitutions. Prior to the widespread adoption of expressed constitutions, like written out like the U.S. Constitution or other constitutions eventually, right? However, a more central question concerned custom. In a hierarchy that required human law to be willed, even custom might have to be understood, at least in theory, to have received its obligation from the will of the relevant lawmaker, and for the custom of England, this meant the will of the people, perhaps even their formal legislative will. Medieval commentators almost uniformly said that long-standing custom shared the same authority and obligation as written law, except that it was made by tacit rather than expressed consent. Tacitus consensus populi rather than expressus consensus populi. The tacit or the silent consent of the people, meaning like when nobody's saying, no, don't do this, silence equals consent, or express consensus populi, the people express, yeah, we want this, right? That's the difference. Accordingly, as Baldus explained, quote, the strength given by time is required not for introducing the custom, but for formalizing the consent. And in the same sense, custom and statute do not differ in their efficient cause and its efficacy, but they differ in their mode and their form. Some commentators, not least Marsilius, pursued the logical authority by lumping custom together with legislation under the old rubric of lex. And Marsilius thus concluded that, quote, under the accepticon of significon of this word lex are comprehended all of the rules of civil rights and utilities, made by ye autocrat of men, as customs, statutes, ordinances, or acts made by the commons. All of these, including the customs, were, quote, the civil acts of men, and were grounded on their authority. Of course, in the learned law, customs were no more lex than English law. Common law was statute. The point, however, was that the custom of a land could be considered a sort of legislation, willed by the people, and in England this not only required that the common law be willed by the people, but also that it be recorded down, written somewhere, right? Exactly how custom could be recorded was something of a mystery, but among the common lawyers who pursued this line of thinking, custom was said to be recorded in popular memory, whereas charters and acts of parliament, quote, are acts reduced to writing. They are always matters of record. In the common law, quote, being only matter of fact and constituting in use and practice, it can be recorded and registered nowhere but in the memory of the people. Although both custom and statutes could thus be considered matters of record adopted by an authoritative body, statutes required not merely a conceptual justification in terms of intent, but an actual effort to discern their intent, and this could be difficult. On the assumption that law had its obligation in its maker's will, common lawyers began in the 15th century, and especially in the 16th, to wrestle with problems such as the hidden character of a lawmaker's mind and the divergent minds of multiple legislatures. For example, in theory, there could only be a single legislative body, but in a representative system of government, the intent of such a body rested in the minds of many individuals, and there were apt to be as many wits, as many heads, and as many minds as there are statute makers, members of the parliament. Notwithstanding the vagaries of intent, common lawyers remained confident that intent could be discerned. The conventional academic solution lay in the lawmaker's words, it being familiar among civilians that words were vehicles, images, and signs of intent. Justinian's code, however, had already criticized those who took advantage of the words of law to depart from its intent, and some civilians, and especially common lawyers, similarly assumed that it was sometimes necessary to seek intent beyond the words. An anonymous 16th century treatise explained that because, quote, words are but invented to declare the meaning of men, we must rather frame the words to the meaning rather than the meaning to the words. Departing further from the academic conclusion that words were images of intent, English lawyers often emphasized the necessity of discerning not merely the intent of the words, but the intent of the statute as a whole. As when Sergeant Saunders argued that, quote, the words are not the statute, but only the image of the statute, and the life of the statute rests in the minds of the expositors of the words, who are makers of the statute, end quote. Words might be, in theory, signs or images of intent, but at common law, it was often necessary to revert more directly to the intent. Indeed, not merely the lawmaker's intent or the meaning of words, but in the statute or the act of the record, for this is what created a legislative obligation. Common lawyers ended up with a two-tiered approach, in which they were initially to discern intent from the words, but were to pursue the intent more generally when the words were ambiguous or obscure. Although these two levels of inquiry were often described in a sort of shorthand as a choice between following either words or intent, both approaches were merely the means of understanding the intent, one being the initial presumption that intent could be discerned from the words, and the other being a recognition that when the words remained unclear, it was necessary to inquire more broadly about the act's intent. The distinction between words and the underlying intent often found expression in the Christian trope of the letter and the spirit, and it was therefore commonplace for early modern English lawyers to argue from the spirit of the law against the letter of the law, and for opposing counsel to respond that the letter was clear or that the letter was the spirit and they were both in accord, all this being a debate about the intent. When pursuing the intent of an act, men sometimes had to adopt equitable interpretations. In particular, when legislatures did not make their intent clear, it could be presumed that they intended what was lawful, and for acts of parliament, this meant that there was just or equitable according to natural law. The locus classicus of such ideas was Aristotle's discussion of Epicuria, that Apicia, the equity that corrected the unjust generalizations of human law. For Aristotle, this justice that goes beyond the written law was only partly intended by legislatures, because although it was intended where they found themselves unable to define things clearly, it was not intended where they had noticed no defect in the law. Common lawyers of the 16th century who were old-fashioned, could still follow Aristotle's tradition and so discuss the equitable understanding of statutes as a matter of directly avoiding injustice. Increasingly, however, common lawyers followed the ideals of authority and therefore said that injustice was avoided in the interpretation of statutes through charitable supposition that the injustice had not been intended, even if it happened, right? The underlying logic was the view, as stated already in the late 15th century, that in every statute one must construe it in accord with the intent of those who made the statute. On this assumption, drawn from the ideals of authority, judges at least by the 16th century, came to recognize that they could pursue charitable suppositions about a statute's intent only when its intent was otherwise unclear. In justifying their equitable interpretation of uncertain statutes, some judges said that an act of Parliament made against natural equity is void, but this cannot be taken out of context. Rather than suggest that they could actually hold an inequitable act of Parliament void of legal obligation, these judges apparently meant that such an act was void of a moral obligation. More exactly, they probably meant it was void in the court of conscience, this being a foundation for their equitable interpretation of the statute in a court of law. If a statute was contrary to natural law or equity, and thus without obligation and conscience, this did not by itself render the statute void in a court of law, for the obligation of the statute rested upon the intent and authority of the lawmaker. Where the intent of the statute was uncertain, however, a judge could not presume the maker had intended an injustice, and therefore the judgment that a statute was void in the interior court of conscience required the judge in his exterior court to interpret the statute to avoid this conclusion. Thus, although it sounded bold to say that an act of Parliament was void, this was merely an attempt to build up the presumption of just intent in the narrow space left by the ideals of authority and the ideals of will. The equitable pursuit of intent could be necessary when the statutes were drafted either too broadly or too narrowly, or a statute was casually drafted so generally that it would work injustice in a particular case. Quote, it shall be taken that it was the intent of the makers of the statute to accept such cases. In contrast, where the statute was drafted too narrowly, quote, the intent of a statute shall be taken further than the expressed letter sucheth. The intent, however, could not be taken against the expressed words of the statute. Summarizing these two types of charitable interpretations of statutes, Chancellor Houghton observed that whereas, quote, some statutes are general in words and particular in intent, some are particular in words and general in intent, but for both, quote, when the intent is proved, that must be followed, close quote. In all of this, there was a risk that for many a judge, the bare letter of the law for him makes no conscience to wrest a law contrary to the meaning of the makers of that law. But this was a reason to be cautious rather than to abandon the pursuit of the intent. Under the guise of resolving uncertainty, there was always room for judges to make moral adjustments in the law, and exactly where the pursuit of intent became manipulation could be difficult to discern. Nonetheless, it was a lawmaker's intent or will that both justified and limited equitable interpretation. Quote, for when the words expressed not the intent of the makers, end quote, it was necessary to interpret, quote, further than the bare words, but ever it must be thought that this was the meaning of the maker. 2 centuries later, Lord Mansfield repeated, there can be no doubt, but acts of Parliament are to be expounded by equity, that is, to have a sound construction put upon them according to the meaning of the legislature, who cannot include in every particular case, not set forth all the exceptions, but the equality of an act can be carried no further than what was within the view and intention of the legislature, and the mischief meant to be prevented. Ultimately, as already suggested, legislative obligation in England rested only on the intent associated with the act of a record. Sorry, I need a little break. We're getting there, folks. We're getting there. Yeah. Whereas in continental theory, legislative intent had to be promulgated at I said theory, not Siri, you freaking thing. Had to be promulgated at common law. It had to be enacted by a court and enrolled in its record. They had to be combined. The standard solution was to speak of the intent of the act. Today, it is commonplace to draw a sharp distinction between the intent of individuals and the meaning of words, to worry about reconciling the actual intentions of multiple legislatures, and to despair of drawing meaning from even a single legislature's intent. Yet, the two elements that created legal obligation, as succinctly summarized in the phrase intent of the act, once required lawyers to ask what the legislature intended or meant in its enactment, and this was not a narrowly literal inquiry, either about the intent or about words, but rather a more abstract investigation which might draw upon the words and upon the intent of individual legislatures, but which sought the intent, sense, or meaning of the act attributable to its maker, in which England was Parliament. In the two-tier analysis, one began narrowly with the words, but when these were obscure, one had to move to a more general examination of the intent. As Edmund Plowden explained in his account of equitable interpretation, this required one to follow the sense of the act, which he also described as the intent of the law and the pleasure of the lawmakers. Plowden was anything but naive, and though his close juxtaposition of several different characterizations of intent, this greatest of early reporters evidently hoped to convey what he meant. In less elaborate versions of this approach, common lawyers spoke ambidextrously about the intentions of the maker of the act and the intention of said act. And precisely because it was at least superficially incoherent to speak of the intent of an act, lawyers could rely on a shorthand expression to avoid a shallow literalism and suggest the depth of what they meant. Of course, they did not thereby escape all the difficulties of discussing intent, but they at least avoided the obstacles that today could so often arise from a narrow literalism. One way or another, intent had to be discerned, for it was the source of the measure of the obligation of a law. And as summarized by the Cambridge professor Thomas Rutherford, quote, the obligations produced by the civil laws of our country arise from the intention of the legislature, and thus the obligation of such a law could only be ascertained by collecting the meaning and the intention of the lawmaker from outward signs, which was called interpretation. Of course, in pursuing the intent of law, one would sooner or later reach a point at which no further intent could be discerned, and beyond that point, the law lacked obligation. Quote, a voluntary law can oblige no further than the lawmaker intended that it should oblige, because all of the authority that it has is derived only from his will and intention, so that whether this will or intention stops, the obligation of the law must stop along with it. Although today this breadth and limit of legal obligation seems elusive and artificial, it once seemed natural. The authority of a human lawmaker and the obligation of his will appear to be derived from natural law, or at least human nature as established by God, and therefore the intention of the legislature was, quote, the natural measure of the extent of the law. All right. Well, it's a bit dry, perhaps, but that's what it is. It's a seminar class, so you take what you can get, and nothing more. So thank you for joining us midday for the stream. Like and subscribe to that cool YouTube stuff. Love you all. Take care. We'll talk to you soon. We'll be back here tonight. More reading. The law school reading never stops. Love y'all.